one looks at the very institution of marriage, and I will now proceed to discuss the issue of breakdown. From Lord Para 6. The title is, when can it be said that a marriage is broken down, and what are the legal consequences of the breakdown? From Lord Para 6. Pertinently, almost all statutes dealing with marriage and divorce, as indicated above, do provide cruelty, adultery, desertion to be grounds of divorce. The grounds for divorce are gender neutral, except that the Dissolution of Muslim Marriages Act is available only to Muslim women for historical reasons. Inevitably, when one party files a petition for divorce alleging cruelty, desertion, and any other party, and the other party also levels counter allegations of a similar nature. This is will have some consequences to the outcome of this case. In the ordinary course, without your lordship's deal, reported judgments indicate that almost all cases are cases where there are allegations and counter allegations. Well, they are not cases of the kind that one can say, well, I'm bored with you, or I don't like your face. They're not those kind of cases, because those kind of cases in any jurisdiction of the world are not considered cases of irretrievable breakdown of marriage. It is these kind of cases which come before the court, where the question arises whether a marriage has irretrievably broken down. Your lordship will take judicial notice of that, and I'll point to the judgments. 7. It is submitted that when one of the parties to the marriage alleges cruelty or desertion, and the others, by the other spouse, it is apparent that the marriage, in a sense indicated by this honorable court in Shivashankar, has broken down. While the court of law is able to deal with the financial consequences of the breakdown of marriage and with the welfare of children, there is no way of dealing with mutual expectations of love and affection and amity. And what I'm saying is that there is an area within intimate relationships, and later I'll develop this idea to say the right to have intimate relationships is also a fundamental right. I'm not able to locate, of course, any judgment of this court which says the right to marry is a fundamental right. But, my lord, it is a fundamental right. It is the right to affiliate, and it is part of the right to form associations. Other courts have held, my lord, that it is part of the right to form affiliations of an intimate nature. And I'll extend that argument to say, my lord, the right to enter into an intimate relationship also includes the right to exit an intimate relationship, maybe for cause. But to unreasonably restrict that right to exit a relationship, my lord, will call into question the validity of the law itself. So, my lord, your lordship will just bear that in mind, that there is an area of personal interaction where courts can hardly interfere. At best, my lord, they can make an effort at reconciliation. That, my lord, undoubtedly, apparently courts have the power and the duty to do that in public interest, to attempt a reconciliation. Whereas financial matters and welfare of the child, my lord, certainly are matters which can be judicially determined and resolved. So that is something your lordship will bear in mind, my lord, while dealing with this case. It is, as I read this, at best the court of law can attempt reconciliation in public interest and in the interest of the children of the marriage. My lord, your lordship is well aware of the fact that courts actually stand in loco parentis to children. And in the best interest of the children, they can do whatever they wish to do on the principle of welfare of the child. That is why, my lord, questions of custody have never presented an issue for the court. It's really the emotional relationship which presents issues for the court. All other issues, my lord, are capable of resolution either by simple application of mathematics. My lord, we know that when it comes to a question of alimony, this court has held that a woman is entitled to be to live according to the standard of living to which the husband is accustomed. There's already a standard, but not fixed, for the grant of alimony or maintenance. But for an emotional breakdown, there can be no standards fixed. So that should be also a factor which would lead the court to conclude that if a marriage is broken down irretrievably, then it should get the imprimatur of the court. Now, my lord, I come to the word breakdown. In the expression, irretrievable breakdown of marriage must be understood in its ordinary meaning, namely, something that has been rendered asunder. The word irretrievable is that what has been broken could not be put together. So, my lord, these are the standards by which courts have come to the conclusion whether this issue is invoked at all. These are the two preconditions, my lord. A multiplicity of factors can lead to the breakdown of marriage, including inter alia, cruelty, adultery, desertion by one or both the parties to the marriage. In other words, mutual expectation of support and amity, which is expected during the subsistence of marriage, disappear and in turn lead to devastating and stigmatizing circumstances. In every case where cruelty, desertion, and adultery are alleged, it is apparent that there is a breakdown of marriage. So, my lord, the breakdown of marriage is consequence of something else. Therefore, my suggestion is that in permitting divorce on the ground of irretrievable breakdown, it is not as if we are stepping outside the framework of established law. We are very much within the parameters of established law. Because, your lordship knows, even under Article 142, the law declared by this court is that you cannot supplant a statutory provision. But, my lord, my suggestion is that by doing this, we are not supplanting a statutory provision. We may be supplementing it. And that is permissible. My lord, in my opinion, the leading case on interpretation of 142 is the Union Carbide case, which will be cited shortly, where, my lord, a settlement, a suit was pending in the High Court. And during the course of an SLP filing in this court, the parties entered into this, meaning thereby the Attorney General of India, representing the Union of India, and my lord, Union Government. They entered into a settlement. And, my lord, the settlement was made an order of the court. Now, my lord, this was done without consulting the affected community, that is the victims. And they therefore filed a petition in this honorable court seeking to challenge that settlement on the ground that they were not heard. And, my lord, it is in that case, the court gave a definitive opinion of what are the scope of powers under 142. And this is one of the parameters they laid down. You cannot do something contrary to statute. The law today, you cannot do anything contrary to statute. But my suggestion is that by allowing irretrievable breakdown of marriage, we are not doing anything contrary to statute. We may indeed will not be or furthering the intention of the statute. That's the submission over here. Now, the word irretrievable added to the expression breakdown of marriage, para 9, indicates that the parties have reached a point of no return in the marriage. The only method known to law to examine whether irretrievable stage has been reached is to attempt a reconciliation with the intention to ascertain whether broken marriages can be put into a state of consortium. The public policy of law in India, as also in the United Kingdom, is that every effort should be made to ensure that marriage should not be broken, since breakdown affects the economic, social status of the parties and also the children, if any. It is for this reason that Section 9 of the Family Act casts a duty upon the family courts to make an endeavor to assist and persuade the parties in arriving at a settlement, and reads as follows: duty of the family court to make efforts at settlement. In every suit or proceeding, endeavor shall be made by the family court in the first instance, where it is possible to do so, consistent with the nature and circumstances